Hello, I'm Rodger Citron, and this is a Toro Law Review podcast. And it's not often we do podcasts ripped from the headlines, but today we are doing one with Baumann. And this is on developments with the Federal Reserve and President Trump. So, Beau, please tell us a little bit about yourself.
Well, thanks for having me on, Roger. So I'm a Ph.D. in law at Yale. Yale has this kind of oddball program where they take people like me and give them about 3 years to do nothing but read and write. Um, on the academic hiring market right now. Before this, I was an appellate attorney at the Department of Justice, kind of doing bread and butter appeals from administrative adjudications. And then before that, I was a law clerk, and then before that, I was a law student at Cornell Law.
Um, and one of the reasons we're talking is it seems that this case, and it is now a case with President Trump's termination or attempted termination of uh, Federal Reserve Governor Cook, just cuts across so many interesting constitutional law, separation of powers, administrative law issues. Um, can you say a little bit about your ongoing research and how it informs what we'll be talking about today?
Yeah, for sure. So, like, I law professors kind of have a brand. And I think if you ask people what my brand was, I have positioned myself in this weird niche where I've got one foot in admin, federal agencies, and I've got another foot in Congress. That's a little bit unusual. A lot of people who do admin, Congress is a little bit of foreign country. And then a lot of people who do Congress, federal admin law is not their thing. So for the last few years, what I've been doing is I've been unpacking the discovery of hundreds of opinions, memoranda, and briefs. It turns out Congress had this unit of lawyers inside the Senate and House offices of Legislative Counsel who would actually resolve lawmakers' constitutional and legal questions with these precedential authoritative written opinions. Uh, which nobody knew about. So what I've been doing is unpacking kind of like the history of Congress's internal legal deliberations from 1919 to 1969 and how those deliberations shaped administrative law and the separation of powers.
Yeah,
This is kind of like the period that sort of matters because the statutory term at issue in the Cook case, which is 12 USC 242, this was developed in the same era I'm talking about. And it was an era in which Congress was trying to figure out how to add depth to the administrative state so that the state would not just be the manifestation of the political will of the guy at the top, the president.
yeah. It's I was struck by that, both in reading the district court decision and some of the things that you have written. Let's take us to current events, if you will, and really just for someone who isn't a lawyer or an economist, can you just tell us a little bit about the Federal Reserve, how Congress set it up, and why we're now here talking today?
Yeah, for sure. So this is a really complex organization we're talking about. So what we think of as the Federal Reserve System is really split up between the Board of Governors, seven governors who serve staggered 14-year terms. Those people are appointed by the president with the advice and consent of the Senate. And they're protected by this for cause provision, which is rather consequential. Okay. And then there's the Federal Open Market Committee, the FOMC. And the FOMC kind of controls interest rates. It sets important monetary policy that, well, there's just no way around it. Like the kind of sets the tone for global economics because of the centrality of the US economy. Um, and then there's 12 regional Fed banks that help implement Fed policy. So it's the interaction between these three different entities. And one thing you gotta know is that the Fed governors serve on the FOMC, right? And this is a blink and you miss it feature of this case, which is the next FOMC meeting is September 16th to 17th. So whether or not Cook is there actually might be consequential in like a really fast moving way.
Yes, yes. And then I want to pick up on when you were talking about your work, the idea of, these statutes enacted by Congress during the time period that you mentioned, 1919 to 69. That is just to sort of reference back to that, because you talked about this idea of Congress wanting to add depth to the administrative state. And I just want to do, if you could, just say a little bit more about that in the context of the Federal Reserve. That is, why Congress, in setting up the Fed, wanted it to be more than merely political, or have depth to it in this way, or as some news talk about the idea of independence with the Federal Reserve.
Yeah, so I really, really sends a shiver down my spine when I hear independence, and that's just me. And the reason why is because the idea that administration could be truly independent from politics is a really dubious notion. So in admin law, there's a whole empirical literature about whether or not these independent agencies are actually independent from politics. Um, and then on top of that, there is no like set definition for what an independent agency is. So like the Fed is a perfect illustration of what I'm talking about when I talk about depth, which is like something that I borrow from a political scientist named Stephen Skowronek. So you have this complex interplay between different institutions that are all under the Fed umbrella. And then you have different mechanisms for kind of separating. Again, you can't be independent from, but separating administrators from politics and instilling other values. It could be expertise, it could be the rule of law. So forget the for cause removal thing. We're so obsessed with that in admin law, these provisions. You've got to forget, you can't treat that like it's the thing. Those provisions are part of a larger project of depth. So like what do I mean by that? Is like the staggered terms on the board, the fact that the Fed has independent litigation authority, that they get to present reports and recommendations to Congress directly by statutory authority outside of whatever the president's doing. So you have to sit back and understand that part of the rise of the modern state was Congress's decision to build a administrative state that had this kind of depth, these different mechanisms, and they are many, for kind of setting off administration from the will of the people at the top of either the president or the people running different agencies.
Yes, yes. And now we come to, that is, I know you're right that, and I'm as guilty as anyone else of, obsessing now about these two words, for cause. But of course, the reason is, and I think this is so interesting in an era, or in a period, I shouldn't say era, it's not long enough to be an era, at a time when we're talking about the president's removal authority, that here it seems like the president is following, or says he is following, the scheme set out by Congress for removing a Federal Reserve governor. And so this is sort of the part, in class where I'd say, can you tell us a little bit about the facts? That is, how did we get to this point where we're now in litigation over the termination of Governor Cook?
For sure. So back in 2023, Lisa Cook, who, by the way, I should just like parenthetically note, like I think sometimes we gloss over like the fact that these are like real people in the world. And like I'll just note parenthetically that in my dive into who Lisa Cook is, she seems like a very interesting thinker and somebody who was not terribly controversial and who is a committed public servant. So I don't want to like lose sight of that fact. I just note this parenthetically that these cases actually involve the reputations of public servants who are trying to make the world a better place for all of us. So just noting that parenthetically.
Mhm.
So Cook is nominated by Biden, President Biden, in 2023, confirmed by the Senate. Um, in between now and then, President Trump, in his second term, takes an increasingly aggressive stance with regards to the Federal Reserve. So some things are going around in the background. Trump wants the Fed um, to lower interest rates and spur more growth in the economy. The problem is that inflationary overhang hasn't really resolved entirely yet. So the Fed has been kind of dragging its feet on actually cutting interest rates. So for a while, he was talking about just axing Jerome Powell, who is the head of the Fed. Um, there is a case called Wilcox. Wilcox is a case that involves other independent agencies. Trump has been gutting this whole idea of independent agencies and asserting presidential control over them, including the FTC, which is the subject of Humphrey's executor, which is a big case here. In Wilcox, the Supreme Court, in a shadow docket opinion, tries to carve out a Fed exception to their march towards the unitary executive. The unitary executive is the idea that Article 2 requires the president's control and ability to remove administrators for basically all Article 2 agencies. But the Supreme Court hints that they're going to try to do an exception for the Fed, and we can talk about why, maybe if you want. So that's all hanging over this. And what's interesting is that some lawyers in the White House are savvy to all these developments. So on August 15th, the head of the FHFA, which is a agency formerly independent, independent, in quotes, sends a letter to the DOJ accusing Lisa Cook of mortgage fraud. So she had tried to get a mortgage, two separate mortgages, one in Ann Arbor, Michigan, and one in Atlanta, right? And the idea is that she listed both homes as her principal place of residence and that this qualifies as mortgage fraud. And the reason that the FHFA director sends that to the DOJ is because it might be grounds for a criminal referral, and it might be for cause under the removal statute. Not long after that, President Trump starts going off on Truth Social saying that this is such a travesty. And then a few days later, and the fact that this is a few days later kind of actually matters when we're talking about the merits of this case. On August 25th, Trump puts out a letter, like I think it's like 2 pages, purporting to remove Cook. He cites both his constitutional authority under Article 2, but he's not using that as the basis for the removal. He's flexing the for cause removal provision that governs the Fed and saying that this is a basically a discretionary call. The quote is, he's removing her, quote, at my discretion for cause. So that is a way of communicating that for cause is basically a discretionary call on the part of the president. Cook files in the DC District Court, and then last night, super late, like I think it was like 9 or 10 is when I saw it. Judge Giacob, who's a Biden appointee and kind of like a civil rights expert, I would say, plaintiff side civil rights, gives Cook a preliminary injunction purporting to kind of like freeze the situation. And the remedial aspect of this is also a whole kettle of fish. This is incredible. So let me just say up front, this is a fast-moving case. and it's incredibly complex, and there's not a lot of good answers. So with that, I turn it back to you.
Yes. No, I have so many questions. And
I
uh,
know.
and so um I, I do think, and I appreciate that very detailed summary, because I think you've essentially stated the president's position and the president's argument. That is to say,
Hmm.
um, Mike, the cause here is these, I think he maybe even referred to them as credible allegations of mortgage fraud. And so that means exactly what you said. I'm following the statute, pursuant to the statute. This constitutes cause, or I'm discharging for cause. Um, Let me just, you know, have we ever seen anything like this before? And I asked that specifically with a Federal Reserve governor, but I think it may even be, let me broaden it to see, you know, what's the world of case law, or, is there a world of case law about termination for cause of such a high level official?
Okay, so the answer here is complicated, and it's actually consequential with regards to how the opinion was written. Um, so first of all, this is new. No one has ever tried to remove somebody on the Fed like this before. This is the first time this has happened. Um, we do not have a ton of case law interpreting for cause at the federal level. We basically have none. Okay. And we'll talk about it in the opinion, but the actual indicia of what for cause means is incredibly weak. Um, in the realm of scholarship, there is a lot more that's been written and a lot of good work on what are called I&M provisions. Um, I&M provisions are kind of, I would say, I would guess more common. I haven't put it side by side, but I&M provisions say that an administrator can be removed for inefficiency, neglect of duty, or malfeasance. And this was a kind of accepted a way of insulating administrators from removal and setting up its terms of their removal. Those I&M provisions we understand a lot better, but the problem is that Congress also sometimes did this for cause thing. They say the administrator can be removed for cause, and that for cause thing is a black hole. We don't know a lot about it. And this is also important, is sometimes Congress said, well, the president has to give reasons, and that comes up in the opinion. Which is also kind of a black hole, to be frank. That's complicated too. So it would be helpful if I answered your question in a way that's not clear on the face of the opinion, which is all of these terms. Congress is and this is just a fact about Congress and all Anglo-American legislatures. They are incredible plagiarists. They look Congress looks below at what the state legislatures are doing. It looks abroad to what Parliament and other Anglo-American legislatures are doing, and it just absolutely will rip people off and not tell you it's doing it sometimes. So that those I&M provisions, they relate to this evolution of law at the state and municipal level that played out across the 18th and 19th centuries. So that's one reason for saying there is a way of understanding what these words meant in a kind of thick way. Okay. For cause is kind of a similar story. So I'll give you an example. And shout out to Noah Rosenblum, who mentioned this case to me, is Biggs v. McBride. Biggs v. McBride is an Oregon case in 1889 that talks about for cause removal and says that you should get notice and a hearing. Okay. So here's one of the oddities of litigating this in federal court is that if you really want to know what these words meant, you would not look at Congress. You probably would not look at federal courts at all, and you put less emphasis on the 20th century. You'd go hard on the 19th century and state and local cases that are trying to flesh out these ideas. And then there's a whole other kettle of fish, which is cases that are trying to say, okay, if you delegate to an official quasi-legislative or quasi-judicial functions, does that imply that when you try to remove them, they get a hearing and notice? And that's a whole other kettle of fish that, like, honestly, like federal courts are not, they're not going to get. So the actual answers here are very complicated. They're very nuanced, and they're not clear on the surface of this opinion that we got last night.
Yes. And can I throw in one complication, which is, uh, and you've adverted to both of these points, and I just want to see how they might filter into the ultimate resolution. On the one hand, on the one hand, there is the president's concern as a matter of policy with interest rates.
Yeah.
And so that's certainly seems to be the principal, perhaps the sole, perhaps not, but principal reason for wanting to remove Governor Cook. At the same time, or rather, because of what for cause, how it complicates the termination, the cited reason is the allegations or credible allegations of mortgage fraud, if I have that phrase correct. And so what I feel, I don't know if it's an independent question, it might fold into everything that you just said, is does pretext matter in terms of how this could play out in terms of, well, I'll stop there because I feel like when you answer that, then we can start to talk further about some of the procedural, the due process procedural points that you referred to. Let me stop.
Okay, so I don't think that we have clear answers to those questions. So, like, what's going on in this case? Well, I don't think anybody really thinks that Cook was removed because of this mortgage fraud stuff. I mean, the reason she got removed is because she ostensibly is opposing the cut in interest rates that Trump wants, and Trump probably also wants to make a spectacle of like asserting control over the Fed. And I will just note parenthetically that people have emphasized the fact that Lisa Cook is a black woman who is getting targeted in this whole fracas, and I'll just leave that on the table. Um, so, like, there's this whole question of pretext, and the fact of the matter is that I do not think there are clear answers on how pretext engages with these terms, partially because these terms were developed at a point in time where our understanding of pretext and its role in law was like slightly less sophisticated than it is today. Okay, so like the actual answer is, as in, like, what is the right answer? I think is under a huge cloud of doubt. And then there's the question of, okay, well, what is the federal judiciary going to do with this pretext problem? And you could see it going one of two ways, right? The Roberts Court's legacy on pretext is a little bit mixed. So in Trump v. Hawaii, you had obvious evidence that Trump was imposing a ban on people coming into the country because he wanted to keep Muslims out of the country. And the court just kind of ignored that evidence, partially because of the president's historic role in the immigration system. Okay, but there's another case involving adding a immigration question to the census that is entirely about pretext, and there the Roberts Court kind of stuck it to Trump. So, I think that the role of pretext is going to have to do with how the court looks at the relevant authorities here. And I think you would be, on one hand, the Fed is the best place where expertise-based authority matters. In other words, these are people with 401ks, and they understand what's going to happen if you subject the global economy to the raw political will of whoever happens to have won the last election. But on the other side of the ledger, you can't forget that they've been marching towards the unitary executive. So are they really going to take a stand on something like pretext in a area in which they think the Constitution commands massive presidential authority? TBD.
Indeed. Indeed. And this is, I was thinking, and maybe we do this through the district court decision, um, the case from the perspective of Governor Cook, that is, she initiated the case, she filed the lawsuit in the district court, um, and I agree with you, the remedy here, so fascinating, the idea of an injunction being issued in this context. But if we hold that and just get to sort of the merits, if you will, that is the claims, her arguments seem to divide into, if I may, as a civil procedure professor, right, a substantive argument about what I did or what I'm alleged to have done, no matter how you frame it or whatever that was, it does not constitute cause. So there's no statutory basis for removal. In addition, or in the alternative, I'm not sure even if which of those phrasings is more, is more apt. Um, well, this is my job. I have a property interest in it, and there are other considerations that go into me keeping the job that matter legally. And so, at a minimum, I was denied procedural due process. That is, posting on Twitter. It doesn't constitute notice. I had no opportunity to respond in a you know in a legal way here. So with understanding that that's her response, let's do it this way. What did the district court say on these points, and what do we think of that, or what do you think of that?
Yeah, for sure. So, I think like the big obvious, I'll lay them out. So, like the big obvious substantive question is this mortgage thing, is this cause under the statute? And then there's two arguments that you could think of as processual, right, about process. One is, does the statute require notice or a hearing? And there are sub issues here, but I'm gonna put the big kind of give you the surface level. And then the other kind of processual question isn't about this. It's sort of still about the statute, but it is about, did she get due process that she is entitled to, right? And then a huge thing that's hanging over all of this, and it's really hanging over all of these questions, is what here is actually justiciable, and that might be the the most important question, in my opinion. Okay, so let's go with the first question, which is this cause, right? Um, the core of the court's reason here is saying that it can't be cause because the for cause provision is about things that you do when you get the job, right? In other words, this mortgage stuff, it's about before she was appointed. And whatever for cause means, it can't include that conduct. And part of this is about kind of this is a term that developed in common law, but it's increasingly becoming relevant to statutory interpretation, is like original public meaning. So what did for cause mean? Um, this is very complicated, but there's a dispute about when you're asking about original public meaning. So the government appointed in 1913 because the Federal Reserve is established in the Federal Reserve Act of 1913. And that's the original origin of this for cause language. So the government is trying to point to like dictionaries and things of that nature to show that for cause is basically like a motive or a reason. And I think I'm characterizing their position correctly when I say that the president just has to give a reason that is not just a policy disagreement. That's where they're putting their flag down. Um, okay, but there's kind of a problem with this, which is that in 1933, Congress passed the Banking Act, which axed the original for cause provision. Okay, which is interesting in and of itself, frankly. Um, and then in 1935, they come back with the new Banking Act and bring back the for cause provision. So what the court decides is that 1935 is the public that matters. And then what she does is she points to a few different conflicting definitions that are around in 1935. One is basically what the government's saying, which is, you got to give us a reason, right? But then she also points to, I think it was like the 1933 edition of Blacks. And Black says that specifically in this context, which is the removal of officials, it has to be something related to like how you're carrying out your functions. And for this OPM part of the opinion, she puts her hat on that. Okay. She emphasizes that the 1935 comes right on the heels of Humphrey's Executor. Humphrey's Executor is the triumph of administrative depth because the Hughes Court rules unanimously that Myers, this previous case that's kind of the origin of the unitary executive, does not apply to quasi-judicial and quasi-legislative functions. We could talk about that all day, but let's not. So the point is that this is passed on the heel of the opinion that is the constitutional foundation for administrative depth. Okay, so that seems like consequential. And then, I would say that a huge part of the opinion is saying that, what do we know? Well, we know I&M provisions. And here she relies on Lev Menand and Jane Manner's excellent work called The Three Permissions, which is a piece that was put out in 2021. And like, in my opinion, is one of the great administrative law pieces that's been produced this decade. And she kind of like goes through the I&M literature and she says, well, like all this stuff is really about like post-appointment stuff. None of this stuff concerns like this kind of mortgage that you filed before you were ever appointed in the first place. And she infers from that for cause must mean apply in the same way, so that this pre-appointment conduct just doesn't really matter. That's kind of the point. Here's what I'll say is that was the best way to execute this move if you were going in this direction and you were ruling for Cook. The problem is that it is totally transparent on the face of the opinion that we have no clue what for cause actually means. She is basically saying we have no clue what this means. The one thing that we can infer is that it applies to post-appointment conduct. That's it. And I will just point out that that is important for this justiciability question, because if we don't know the standard, why is this justiciable? If the only thing we know about this provision is that it applies to post-appointment conduct, does that imply that we should be pretty cautious about our claims to certainty in this area? I mean, there's a core weakness baked into this whole case, which is we have absolutely no clue what for cause means in the litigation itself. And we have barely a better idea of what it means in the academic literature. Okay, so that's a huge problem. Okay. And then there's like the question of like, does the provision require notice in a hearing, right? That's kind of complicated in and of itself. We have one example. This is one of the reasons why it's complicated. One of the best pieces Aditya Bamsai ever wrote was about the one time somebody gave a hearing to somebody who was removed under one of these provisions. I think it was under Taft, right? The problem is that in that statute, there actually was a provision that gave you a hearing. And its absence in the Fed context looms pretty large. So that's the problem for Cook that she needs to get over. And then there's this whole other kettle of fish, which is, does she have a entitlement to due process, which would raise questions of notice in a hearing. This is the most hand-wavy part of the opinion because and it's rather short for what is an incredibly complex and complicated or consequential question. The court basically pivots to like what's a classic case in this canon, which is called Loudermill in 1985, and says, there's just some public employees who, because of the nature of their position, are entitled to these expectations of notice in a hearing. should that 1985 case really control the expectations of a hearing and notice for the Federal Reserve that was essentially crafted in the first part of the 20th century? Who knows? That's like the thing that they're going to have to develop once this is beyond an emergency posture. Like, there's not a lot to talk about there just because there's not a lot in the opinion. Okay, questions.
Yes. And you made a reference, it was quick and I almost hesitate, but nonetheless, OPM, because I also worked at the Department of Justice, that would be the Office of Personnel Management. And that's how you were sort of, if you will, sort of framing or the context in which you were talking about, this from the
No,
perspective of the termination. That is what it meant for Cook holding a
no,
job.
no,
Is,
no.
oh, am I
I'm glad
wrong?
you asked that. No, I meant original public meaning.
Oh,
So when
OPM,
you
I beg
talk,
your pardon. I
so
beg
what
your
matters
pardon.
here, and this, I'm glad you pointed this out because this is actually confusing, which is what I'm saying is, when originalism got going, what was the big shift? It was a shift over to the evidence that matters is evidence of original
Oh,
public meaning.
yes.
What did the Constitution mean to Joe Blow on the street? Increasingly, and you see this with people like Amy Coney Barrett or and others, we're interpreting big statutes that have been around for a long term in the same way. So, what did the Banking Act in 1935 mean to Joe Blow on the street?
Thank you for clarifying my purported or attempted clarification. Um, and the piece that the question I sort of want to follow up on, because it really picks up on the procedural point that is that we've been talking about. That is, what kind of process, if any, is Cook entitled to here? Is um, so who would be the decision maker? Who would be the decision maker before we got to court? And then you then said, when you referred to justiciability, assuming that there is some kind of pre-judicial process. That is, I know we're in a lawsuit now, but hypothetically, one possible cure is okay. Some kind of hearing has to be held, and then perhaps after that hearing is held, you can come back to court, perhaps. Um, and then, so one question would be, do you have any thoughts on how, like, any prior judicial hearing could be conducted? And I know that the question's a bit long already, but I also want to ask in that, because I think they're sort of floating around. I know there's a reference to Loper Bright in the district court's decision, and that is to say, that seems to be perhaps in tension with the language of the letter. That is where President Trump says, well, I'm exercising my discretion. That is, I get to say or define what cause is. And that could be in tension with Loper Bright saying, well, actually, the court gets the final say. And I will add, she not only cited to Loper Bright, but per John Roberts, Chief Justice John Roberts, it's followed by a citation to Marbury about, right, courts say what the law is. So it's a compound question. Let me stop with those two questions if we can distill it down to two.
So I feel like this is going to be a drag for people listening because, like, the last episode of your show was like people were taking pretty clear stands. We were like, "What's the right answer?" And there was like a little bit more to hang on. And I think anybody who tells you with any surety what the answers are here is like selling you something because like we don't know. Like, assuming that she's entitled to due process, like we have no clue who the decision maker is. We have no idea what kind of hearing and notice she's entitled to. So like there's even a sub question, which is, okay, Trump does his truth social thing where he says, oh, this is a huge problem, this is a scandal. And then he waits a few days and before purporting to remove her. Okay, is that notice? Who knows? And like the problem here is like the very fact that Congress like didn't flesh any of this out kind of leaves you without law to hang on. So like one of the things that I do in my work is I talk about like judicial self-aggrandizement. And that's a term I tried to flesh out with Alan Summerall and Josh Chaffetz. It means when judges deploy ideas and rhetoric to aggrandize themselves in the separation of powers. Okay. So all of that stuff about like, well, it's the court's job to say what the law is and all that stuff. It's a really good way of taking people's eyes off the transparent fact that there's not a whole lot of law here in the first place. And that's the problem is we don't know. There's so many questions in this case that we don't have a really good legal hook. The question is, why is this in front of courts in the first place? Like, and you were asking about, well, like, what's the relationship between the due process, hearing and notice, and subsequent judicial review? Who knows? Like, that's the biggest problem. In some ways, this case has eerie vibes in common with Trumpy Anderson. So like there was this huge dispute about whether or not Section 3 of the 14th Amendment precluded Trump from running from another term because of his actions surrounding January 9th? January, I forget the date, January something attack on the
Yes.
Capitol in Congress. It's been a while, guys. It's been a while. Um, and you know, I remember I published an op-ed around that time where I was like, you know, we are running to the Supreme Court to try to kick Trump off the ballot. That seems incredibly unlikely to work. And I published an op-ed saying that. And lo and behold, like 9-0 in an opinion that has almost no originalism in it whatsoever, the court just like guts that portion of the 14th Amendment. So like the vibes are very similar here is what I'm saying. You've got a hugely consequential case and you've got a question that has no clear legal answer. So, you know, like if you're sitting at home, the question you have to ask yourself is the Supreme Court and the Roberts Court that we've been seeing play out over the last 9 months, are they going to take a stand against this precedent on a case in which all of the legal questions are incredibly underdetermined and there are no clear answers? Like, is this really where you think they're going to take a stand? That's kind of like the framing I would provide to people who are watching this case. And it's an interesting framing because who knows, but
Yes, I will say my 2 cents on the Colorado case, and that is, it was sort of the most prudential or consequentialist. That is, it was so much driven by we're not going to do this, or we're not going. In other words, we're shutting this down because it felt like we can't institutionally, and I say that not just judicially or for the Supreme Court, but even I think even more broadly as a society, we're not going to entangle elections in a legal process, in litigation like this. So, you know, that's my very rough paraphrase. Um, and and if that's how this case feels, that is on top of all the very complicated legal questions we've been discussing, um, and the court wants to, employ some kind of passive virtues approach here to get out of sort of confronting the president on, an important, consequential, complicated policy matter. I I wonder if you can, is the way out um, to avoid the case entirely by denying cert, to nonetheless take the case but deal with it in some kind of summary fashion. I mean, it seems like it has to play out very, very quickly.
here's what I'll say is I think that the Achilles heel of the opinion that we got last night is justiciability because there is no way to rule on this case on the merits and meaningfully enforce whatever principles you decide upon that doesn't involve judicial policy making on such an epic scale that I think it will make even the biggest aristocrat in the country, it's going to make their stomach churn. Okay, but there's one other consequentialist thing that's on the other side of the ledger, which is again, these are people with 401ks and they understand what it would mean if the Fed is subjected to unadulterated like presidential will. So I'm not telling you I know the answer to this question. I'm saying if they want an out, they have an easy out, and the easy out is justiciability, and saying that there's just not enough law here, there's not standards that could provide for meaningful judicial review. We're piecing out, and I think that that would be in keeping with what they effectively did in Trump v. Anderson.
Um, this has been really, 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 truly interesting. And the fact that so much of the conversation, I feel like, has been sort of prefaced by the caveat well, no one really knows because we don't. I feel like it's been very illuminating. So I thank you for that. I did want to have sort of, and you, we've touched on it, and I don't know if there's anything more to say, but I just want to give you the opportunity, sort of pulling back, from the case itself and the legal issues. This is such an interesting separation of powers case. I think that, there are many sort of issues or sub-issues, if you will, of constitutional politics here. You know, in the broadest way possible, what does this case tell us about where we are in the United States, politically and legally right now?
Well, it tells us a lot. It On the one hand, I think that this is a story that's really important for administrative law, which is, I think one of the reasons that no one had ever tried something like this before is that people in a certain Americans at one point in time really bought into this idea of expertise-based authority. And I think that if a president had tried to do this and to make the Fed an instrument of raw political will, I think that would have been a political controversy of the highest order. And the fact that Trump is able to do this, and if I had to guess, is probably going to get away with it, is a sign that the purchase of that model of governing authority that turns on experts insulated from politics is dead, dying, or has taken a real hit. But that would lead you to a bunch of interesting questions, which is expertise-based authority is like at the core of what administrative law is, how it's conceptualized. So what that would mean if you really were concerned with like, well, what's next is you basically have to start from scratch and rethink this whole like administration thing in America. So that's like that's like a generational project. Like that's a huge generational project to rethink the stories we tell, the ideas that are at the core of this entire field. Okay. The other thing that looms large is, we have two players that are really kind of in the last throes of a huge assertion of power across the last 100 years. You've got the presidency and you've got the judiciary. The story of the last century of American political development is about the concomitant rise of presidentialism and juristocracy. Okay? Trump is blasting the old order in real time, and he is having to negotiate the terms of his project with the last game in town, which is the juristocrats, the courts. And he is not asserting a constitutional authority to remove the Fed. He understands his position, and he is trying to go through a more legalistic route that allows the court to save face. So I think you're watching really complex dynamics of regime change. And I think that you are watching a president with a keen sense of what's happening around him operate pretty deftly, in my personal. I know that's not a popular opinion, but I think he is operating really quite deftly in his exercise of authority and the optics of it all. Um, and is this good for the public? Probably not, but sorry. Um,
Right. Well, not every story has a happy ending. And
yeah,
so, and we don't know. And to be clear, just to reiterate, we don't know how this story will end. Um,
true, true.
so, so yes. Um, Thank you so much. It's really been a pleasure. And um, I wish you well on the job market and look forward to staying in touch. Thank you so much. That's the podcast.
For sure, Roger. Thank you so much.
Bye bye.